All right, well, welcome to Constitution Day. And this is, I think, maybe my 7th or 8th Constitution Day over at the School of Law. And it's really a great event. Appreciate everybody being here today. I think this is an important event in that it really brings the entire campus together, faculty, advisors from literally across the campus, students from across the campus, to talk about some of the timely issues related to law at that point in time. And over the years, I try to some of the previous topics. We've talked about a number of important topics that were timely, and in many cases remain timely. We've had some great discussions from our experts who come from the preeminent institutions from around the country, and I want to thank you for being here, both of you for being here today. What I've also enjoyed about this is that the students really run this process. I sit and listen and watch to the students ask the questions, the tough questions, and then of course the audience has that opportunity also to do that. Let me just again say this is an important topic today. You know, I'll read it. It's sexual misconduct on college campuses, justice and due process. This is obviously a very important topic. Those of you who keep track of these things nationally, and it's been an important topic since several years ago, particularly beginning with the Dear Colleague letter. And every institution on campus, including Case Western Reserve University, has really worked hard to advance our work in this area, to make sure that we have a culture and a climate here that is safe and it is respectful. And it's one that I think, as some of you know, led to revisions to our sexual misconduct policy. We just actually hired a Title IX officer who was previously Marilyn Mobley, but now this is somebody who is entirely in that position. So we're continuing institutionally to ramp up our activities in this particular very important area. So again, with that, I will just thank everybody for being here, thank our students for your participation, thank their advisors, and welcome you again, and let's get on with the show. Thank you.
Thank you, Provost Baselak. Good afternoon, distinguished guests, faculty, students, and friends. My name is Erin Howe, and I am the Mistress of Ceremonies. The purpose of today's forum is to celebrate the 228th anniversary of our founding charter, the U.S. Constitution. It is an honor to welcome Professor Cynthia Bowman from Cornell University Law School and Mr. Howard Kallem, Director of Title IX Compliance at Duke University. Professor Bowman and Mr. Kallem, the Constitution Day Student Committee appreciates your taking the time to speak and answer questions on how Title IX and the 6th and 7th Amendments relate to sexual misconduct on college campuses. Highly publicized cases and faculty criticisms of newly adopted policies make this an important issue of our time. This forum will address the application of the Constitution, the effects of pertinent federal laws, and whether university hearings by themselves can deal with misconduct. I would also like to introduce our moderator, Nicholas Poe, and our panelists. From my left, Elijah Newcomb, Peyton Henderson, and Daniel Williams.
Thank you, Ms. Howe. Ladies and gentlemen, Title IX prohibits sex discrimination in education. Since its passage, the federal government has set standards on what colleges and universities, both public and private, should do to comply when dealing with sexual misconduct. Law scholars and professors have raised concerns about the relationship between the federal government and universities. For example, how can justice and fairness be best served when a person claims to be sexually victimized by a fellow member of a university community? What is the proper role of the university? How can the rights of both the victims and the accused be balanced and maintained? Such questions have swept across campuses in our republic. They are indeed timely and provoke controversy. Please silence your cell phones and hold all questions until the end of the program. Mr. Kallem and Professor Bowman will each have 10 minutes. Following their statements, the 3 student panelists will pose questions to our speakers. Mr. Kallem, the floor is yours.
Thank you very much. So Cynthia and I talked before when we were preparing our remarks, and we may not stick exactly to the agenda. I don't know that this is going to quite be a debate as the setup might indicate. There are some points where we will disagree, and a number of points I think we will agree. But a little bit more context is what I thought I'd provide to get us started. As you said, Title IX of the Education Amendments of 1972 prohibits sex discrimination, which includes sexual harassment. It applies to schools, at the public schools, K-12, and colleges that get federal funds from the U.S. Department of Education. And that includes every public school district in the country and almost every college and university in the country. It is enforced by the Office for Civil Rights at the U.S. Department of Education, an agency where I used to work, with the occasional involvement, I might even say from my government experience, occasional interference by the Department of Justice. Sexual harassment is unwelcome conduct of a sexual nature that is sufficiently serious, that is severe, persistent, pervasive, to interfere with, in some way with a student's participation in education or an employee's ability to do their job. From both a subjective standard and an objective standard. It actually has to be serious enough to make it difficult for the student employee to be able to learn or work, and it has to be reasonable for them to have that response. OCR has been addressing issues of sexual harassment and sexual violence for quite some time, issued its first guidance on this issue in 1997. Shortly thereafter that, there were two Supreme Court decisions, Gebser versus Lago Vista and Monroe v. Davis, that recognized that, in fact, as OCR had said, sexual harassment could be a form of prohibited sex discrimination under Title IX. And one of those decisions, the Gebser decision in particular, recognized that OCR has the authority to promulgate and enforce requirements that effectuate the statute's non-discrimination mandate. Again, the authority to promulgate and enforce requirements that effectuate the statute's non-discrimination mandate, meaning measures that might go beyond the exact language of the statute, but in OCR's administrative enforcement mechanism, ways that would help enforce it. And that would apply to grievance procedures. And I'll come back to that in a minute. So the 97 guidance was issued, then the Supreme Court decisions came out, 2001. The guidance was revised by OCR to recognize and address some of the issues that the Supreme Court had raised. In 2003, OCR issued a Dear Colleague letter, the letter to school superintendents and college and university presidents on how the First Amendment and academic freedom and free speech interplay with issues of sexual harassment under Title IX. Then in 2011, there was another Dear Colleague letter that came out that specifically addressed sexual violence as a form of sexual harassment. And then in 2014, OCR issued some questions and answers that provided further guidance. The reason why we are here is because as part of its regulations, OCR includes a requirement that schools and colleges and universities have prompt and equitable grievance procedures for complaints of sex discrimination that students and employees can use to file complaints internally about sex discrimination, including sexual harassment and sexual violence. And those regulations are really the foundation for much of what OCR has been doing in terms of its regulations, the guidance it's issued, as well as the investigations that it's conducting, whether or not the schools have grievance procedures that are prompt and equitable. And there are about 140 or so open OCR investigations right now involving colleges and universities on the issue of sexual violence, and there are 40 investigations against school districts on the issue. Another federal law that applies in this situation is the Clery Act, as amended by the Violence Against Women Act. And it has regulations which took effect fairly recently. Among other things, it requires colleges and universities to have procedures in place to resolve complaints of sexual assault, dating violence, domestic violence, and stalking. Unlike Title IX and its implementing regulations, which simply say prompt and equitable grievance procedures and no specific requirements beyond that, the Clery Act regulations do have a number of specific requirements for these procedures. So this has been an issue in large part for the current administration since about 2010. There was a report issued by a nonprofit group called the Center for Public Integrity, which generated media reports. OCR had information indicating that colleges and schools weren't recognizing that sexual violence was even a form of sexual harassment. Well, it's criminal in nature. We should be deferring to the police. But if you think of sexual harassment as being unwelcome conduct of a sexual nature, well, sexual violence certainly meets that definition, and it's serious enough to interfere with the environment, or that they weren't responding promptly enough. So as a result, they issued their Dear Colleague letter. That was followed by some high visibility complaints by students and interest groups, which led to more publicity, which led to more complaints, and so on, and it's been in the news ever since. There are several different models that schools use for their grievance procedures. One model is sometimes called the single or pure investigator model, where there is one person, an investigator, who does the investigation, makes the determination, may well decide the sanction, and perhaps even decide on the remedy. There are some advantages of this, and we'll get into that, I suspect, during our conversation. It is by far the quickest method than many other mechanisms which have multiple steps. And the major advantage is you can have one person who's well-trained and has experience in the issue, conducting the investigation and making a decision. Another model that some schools use is a hearing-only model. No investigation at all. The parties walk into a hearing where the issues and facts are developed for the very first time. The third model is a hybrid of an investigation and hearing. There may be an investigation that just has fact-finding with an investigative report that's presented to the hearing panel, or the investigator may make some sort of finding, but then it's followed by a hearing, usually a de novo hearing, that is a hearing. They start from scratch using the information. They're not bound by, and that came up in the investigation, not bound by the investigative report or the determination. Interestingly enough, the Department of Justice is going to be issuing a grant either this month or next month that will study these various models and the advantages and disadvantages of them. So one question that I know we're going to talk about is how the Constitution applies to all this. Certainly the 14th Amendment does, federal due process requirements, and the Supreme Court has spoken to this, notice of charges, disclosure or explanation of evidence, and the opportunity to be heard or to challenge the evidence. Those are the basic tenets of due process applicable to state actors. They don't apply directly to private entities. In fact, working at a private school, we don't even use the term due process. What we talk about instead is procedural fairness. We believe that the principles of due process and fairness should apply to it. We want our procedures to be fair and balanced, even though we're not directly subject to the Constitution. And as OCR itself has said, procedures that comply with Title IX, but at the same time accord due process to both parties, will lead to the most supportable and sound decisions. Some of the issues I think we're going to talk about today probably will be standard of proof that is used in these campus disciplinary proceedings, perhaps the burden of proof, who has the obligation to prove what, role of attorneys and advocates, whether there's a right to cross-examination, whether the parties have to be in the same room together and see each other, whether there's a right to confrontation, as there might be under the Sixth Amendment, whether to proceed even if the reporting student doesn't want to do so, what to do if the responding party, the accused student, refuses to participate, and fundamentally, whether we should just turn this over to the police and the university shouldn't be involved at all. Thank you.
Professor Bowman.
Well, thank you for inviting me here, especially on such a nice day. There are many, many things on which Mr. Kallem and I agree. First, of course, we agree on the necessity of addressing the problem of sexual assault on college campuses, which has been a major obstacle to the equality of education for women. I've spent a large part of my professional life writing about and seeking remedies for violence against women, and sexual abuse of various sorts has been a major part of my research. Legal remedies, of course, are only one route to address this problem. a societal change in attitudes toward women and towards sex is necessary, and the impact of the legal system is somewhat limited, but it is still very important. I'd like to pick up the narrative that Mr. Kallem just described at the moment when universities received the Dear Colleague letter from the Department of Education. My own reading of that letter was that it gave notice to universities that the department intended to take their responses to sexual assault very seriously, to monitor them, and investigate charges of failure to meet their obligations under Title IX, as they were already doing. While contemplating that universities would use a variety of procedures, the letter required that they all determine cases of alleged sexual assault under the preponderance of evidence standard. Some universities reacted with defiance. Some just dragged their feet and did little to change their past attitudes or ways of behaving. And investigations, as Mr. Kallem has said, were undertaken against many of them. Most of these settled on the department's terms. And my concern is not so much with that development as with the response of universities like my own and others who responded to the Dear Colleague letter by instead rushing to over-comply with it. The fear was, of course, that they would lose federal funds. And that is, of course, legally possible under Title IX, but it actually has never happened. A concern I'd like to raise as well, a kind of side concern about the Dear Colleague letter, is that it was just that, a letter. Until translated into regulations and put up for notice and comment, and then promulgated, it did not have the force of law. But it did strike fear into the hearts of many a general counsel's office. So here I'd like to tell you about my own involvement in this issue, which takes up from before then. From 2008 through 2012, I was the chair of the Cornell University Review Board, which is an appellate body that hears appeals over all campus code violations that have come up through hearings. And that included ones based on allegations of sexual assault. So in this capacity, I did become familiar with the facts of many of these cases, which I took to be somewhat typical. Most of them involve consumption of immense amounts of alcohol by both parties, hard drinks before a party, continuous drinking at the party, accompanied by ambiguous communications, tweeting and stuff like that, between the two persons, and a stumbling trip to someone's dorm room. Sexual contact began at the party, apparently totally consensual, and continued in the dorm until it culminated in intercourse that was unwanted by the female. Many cases involved freshmen who were new both to sex and to heavy drinking. Others involved students from different cultural backgrounds with differing assumptions about sex. Our procedures included a hearing in which the complaining witness was represented by the judicial administrator, a university official, a lawyer, and the defendant was represented either by a lawyer or by a law student trained for that purpose. Hearing boards consisted of a mix of faculty, staff, and students, and were often presided over by a law professor. It's not possible at a school that doesn't have a law school, right? Hearings were less formal than a court trial, and rules of evidence were relaxed. The same was true of the appeal, at which both parties could appear with their representatives. Dispositions handed down ranged from sanctions like no contact orders, changes in class schedules, in dormitory assignments, temporary suspensions, community service, mandatory counseling, and other quite creative remedies in many of them, up to, of course, expulsion. After the Dear Colleague letter, the university administration took jurisdiction of all sexual assault cases away from the campus code procedures and placed them in the hands of an administrator who functioned as investigator, prosecutor, and adjudicator all in one. Deciding cases under the preponderance of the evidence standard, we had our campus code procedure proceeds under the standard of clear and convincing evidence. There would be no lawyer, no hearing, no cross-examination of witnesses. In other words, most of the basic protections associated with fairness in our legal system were absent. Several law school colleagues and I noisily fought these changes, but to no avail. I warned the general counsel that in their fear of liability to victims, they were opening themselves up to lawsuits by offenders who were punished without adequate procedural protections. Those cases have now been brought, including against Cornell. Many of them around the country have settled, usually on a confidential basis, and at least one has been won in federal district court in San Diego on the grounds that the accused student's right to confront the evidence against him was unfairly limited, including admission of a report by an investigator who was not present at the hearing. In October of 2014, 28 Harvard law professors placed an op-ed article in the Boston Globe raising many of these same concerns that I had. In it, they decried Harvard's new procedures, and specifically the absence of any adequate opportunity to discover the facts charged and to confront witnesses and present a defense at an adversary hearing, lodging the functions of investigation, prosecution, fact-finding, and appellate review in one officer, and the failure to ensure adequate representation of the accused. In January of 2015, the White House Office on Women and the General Counsel to Vice President Biden called a small group to the White House to discuss our objections. 5 law professors, including myself and 2 from Harvard and 2 others, met with those White House officials and representatives of the Departments of Education and Justice who are concerned with this issue. The White House officials expressed surprise that those of us long associated with women's rights were opposing their new policies. And each of us in turn said that we had never expected to be pushed into such a position, but that our concern for the rights of accused students and the integrity of our institutional procedures had driven us to it. All of us were convinced that it was possible to confront and to punish sexual assault while still respecting the rights of accused persons. This summer, 2 bills have been introduced into Congress reflecting some of these views, the Safe Campus Act and the Fair Campus Act. I support the second of these legislative initiatives. Each bill provides to both alleged victims and accused students the right to hire lawyers who may represent them throughout the process and allows them to examine witnesses. They guarantee both parties access to all material evidence at least a week before a hearing. They prohibit individuals from playing multiple and thus potentially conflicting roles in the investigatory and adjudicative process. And they repeal the mandate that institutions use the preponderance of the evidence standard in hearings, leaving this to the individual educational system. My disagreement with the Safe Campus Act, which has also been opposed by almost every sexual assault prevention group in the country, is that it requires that a victim of sexual assault report the accusation to state law enforcement or forego any campus procedure. I think that is a tremendous mistake for reasons which I can elaborate on, but I'm out of time.
Thanks, Professor Bowman. We will now take questions from our panelists, beginning with Mr. Newcomb.
Professor Bowman, the Sixth and the Seventh Amendments guarantee the right to a trial by jury in both criminal and civil cases, respectively. The Sixth also guarantees the right to face one's accuser and the right to counsel. Are these provisions applicable to college investigations and hearings?
No. No, they're not. I mean, the Seventh Amendment doesn't even apply to the states. And this is not a criminal proceeding. So I don't know how to talk about this for 5 minutes, but no, they don't apply. The underlying reasons why you would ask me about them have to do with rights to confront evidence and witnesses against you, which are guaranteed in the Constitution, and that applies to criminal trials. And I think that in our justice system and in our society as a whole, we've come to associate those guarantees with what you called, Howie, procedural fairness, what it is. And that, so if we set up some institution for judging something, we think you ought to have certain things. And you ought to know what the evidence against you is. You ought to be able to ask the people who are saying things about you. You ought to be able to have a hearing before an impartial decision maker. So I think that those don't, strictly speaking, apply, but that their analogs do apply and should apply in the university process.
Yeah, Mr. Kallem.
Just to build on what you had said, campus disciplinary proceedings generally are considered, and this is actually written into many of the procedures, they're educational processes. They have an educational purpose and an educational mission. They're not criminal in nature. Nobody goes to jail because of a campus disciplinary hearing. They have, the hope is that through this process, the people that are involved will reflect on their conduct and learn from the proceeding. Doesn't always happen, but that is in fact what the intent has been in developing these procedures. The tension sometimes can be balancing either due process or procedural fairness with that educational mission. And that has led, I think, to some of the concerns that Professor Bowman, that Cynthia has raised, that we're going to be we've talked about a little bit already, and we'll be talking about some more.
I just want to say that although it's not a criminal proceeding, that it's not exactly a civil proceeding where the two parties are on equal grounds either. That the sanctions include much more than education and can be very serious ones. And if, for example, it involves expulsion from a university, that has really serious consequences for a student's life in the future, including certainly whether they could go to law school or be admitted to a bar.
Yes, absolutely. And that's true for a variety of student misconduct, not just limited to sexual harassment, sexual assault, although much of the current conversation about expressing concern for the rights of accused students is couched in terms of, or even limited to, sexual harassment, sexual assault. There's something about that issue, and I can speculate about why, and maybe we'll later, but there's something about that issue that brings people out of the woodwork to complain about how responding parties are being treated without those same concerns necessarily being raised when responding parties, students, are being accused of theft, of physical assault, of racial harassment and racial assault. You don't necessarily, often don't see the same kind of vehemence and arguments being made in favor of their protections, their procedural protections that you do in the context of sexual harassment and sexual assault.
Ironically, now at Cornell, all of those get the prior procedures, which were very adjudicative and have all of those protections.
But
and now it's only sexual assault violations that have been taken out. I think we went beyond what we're supposed to do.
Okay.
Yeah.
But that'll happen some more, I think.
Mr. Kallem. The Office of Civil Rights issued a letter about sexual violence on campuses, setting standards for what universities must do in order to comply with Title IX. Law faculty in many universities raised concerns about due process for accused students. Briefly put, those who signed the letters believe that, in an attempt to protect victims of sexual assault, their respective universities sacrificed basic elements of fairness and due process. Mr. Kallem, should the accused be granted a right to counsel in preparation for the hearing and a right to cross-examine witnesses?
Okay, first of all, it's the Office for Civil Rights, not Office of Civil Rights. I worked there for 25 years, and so that was a constant source of irritation for us. So the question is whether the accused student should be given a right to counsel and and what was the second part?
A right to cross-examine
Right to
witnesses.
cross-examine. Okay. So right to counsel. Now, Title IX doesn't address this. What the OCR's guidance, sub-regulatory guidance, it's not, as Cynthia said, not force of law. What OCR's guidance does say is that if the responding party has an attorney, then the complaining party also should have an attorney. And the reason why OCR took that position is because for many years, the primary focus of campus disciplinary procedures was on protecting the rights and according rights to the respondents. Title IX is a civil rights law, and it's enforced through schools' codes of conduct, but many school disciplinary procedures were not set up to acknowledge that what they were dealing with when they were dealing with sexual harassment was different than plagiarism, was different than some sort of maybe more victimless crimes or infractions, I'm sorry, and that there was a civil rights interest at play here. So they took the position of, well, if the respondent is getting all these rights, then to be fair and give the protection under Title IX, then the complaining party, the reporting student, should have that as well. As it turns out, the Clery Act, the Violence Against Women for cases of sexual assault and relationship violence and stalking, the regulations there and law do require that students be allowed to have attorneys on both sides, but they allow the schools to limit the role of the attorney. And in North Carolina, there's a state law that gives the attorneys that has that same right and gives the attorney the right to fully participate to the same extent as the student. So that means that the student could just sit down and let the attorney handle the entire proceeding. And we've seen cases like that, and generally they're a mess because the process, which started out as supposed to be an educational process, has turned into a mini courtroom. The lawyers think it's a courtroom. They're doing grandstanding. They don't understand that the standard of evidence and that we're not limited by hearsay rules, and they really wind up getting in the way of moving the case forward. And our hearings went from being 3 and 4 hours to being 6 and 8 and 10 hours, in large part because of the role of the attorneys. Other schools use this potted plant rule. The attorney can participate, but is limited to consultation and quietly advising their client. So it's happening. I'm not sure that it's the best thing to happen, but in most cases, they are getting an attorney. Now, there have been some court cases that have addressed the issue of due process. Over the last couple of 3 years, there's been about 24 cases that have been decided on, brought by respondents challenging school decisions, finding them responsible. About 16 of them have been found for the university. 2 were mixed, some findings for the students, some findings for the university, and 7 were found for the students. And many were settled. But there have been some court cases which have said that the fundamental issues of due process, notice of charges, disclosure or explanation of evidence, an opportunity to be heard or to challenge the evidence, doesn't require participation, a right to an attorney. But I think most schools are, because of the Violence Against Women Act, are allowing students to have attorneys as well. The right to confront the other party, well, it depends on what you mean by confront. Certainly they have the right to have the information that the other party has presented, to know what that is, to question it, to challenge it in some way. Whether they have to do that in a face-to-face proceeding, or whether simply finding out that information from the investigator who has spoken to the complainant, then relays that information to the respondent, and the respondent then can respond and provide their side of the story. Again, there have been court cases which have said that that kind of a model, that single investigative model, perhaps followed by a hearing, but that can be enough to provide that minimal standard of due process. Whether we want to provide more than that minimal standard, that's a fair point. But we can give that opportunity to question the evidence through some sort of process. And then the last thing I'll say is that, and I think this is an area where we may agree, it doesn't have to be in person. Even at a hearing, it doesn't have to be in person. If to go through a sexual harassment, a sexual assault investigation and hearing can be tremendously traumatic for the reporting party, having to be in the same room with the person who may have sexually assaulted them can re-traumatize the complainant. So what many schools do is they put in a screen so they don't have to see each other. They may allow them to participate via Skype, but they will, and this is something that OCR has strongly encourages, well, rather they strongly discouraging allowing the parties to directly cross-examine each other. And so schools will generally, in a hearing, allow the parties to ask questions of the other party through the panel, through the hearing panel. And that can work. Sometimes schools get in trouble for that because they may screen some of the questions out that they may feel are irrelevant or prejudicial. And there have been some court cases which have said that they've done it wrong, that they have screened out questions that in fact were important.
I'm wondering where your timers are going. Okay.
I'm getting time over there.
Oh, you are? Okay. I
And I'm
see.
going over it,
My
too,
guys
routinely.
are, okay,
So I apologize for
wondered.
that.
I just wondered. Okay. I'm just asking. Well, we disagree on this, and maybe I'm sort of brainwashed from being a law professor for so long and a lawyer and litigator before that and still. But I think the role of attorneys is a positive one. I think it helps rather than harms the process. I know that a lot of universities are really concerned about letting attorneys into these proceedings. And as somebody who's tried a case against a pro se party on the other side, I'm all for having an attorney. The attorney knows what the legal issues are. They know what the evidence is that's relevant to those issues, and they know how to go about kind of structuring the case. I think that their presence and ability to speak during all of these proceedings can only improve the accuracy of the proceedings, their fairness, and I think probably the feeling of safety that both parties have when they have an advocate. You know, I mean, that's what I feel like I do when I'm a lawyer for somebody else. You mentioned that there might not be a hearing. That's the bottom line for me. There's got to be a hearing. I'll talk more about that when I'm not under such small constraints, but I think a hearing is a basic element of due process. And I agree that cross-examination is not going to be the same as confronting somebody in a criminal trial. I think that that's inappropriate in these proceedings, particularly because of the traumatic nature of the proceeding for the victim. And I am certainly looking for schools to come up with creative ways of being able to substitute for the in the same roomness, right? Whether it be by closed circuit television of some sort. But the victim certainly, in my mind, can be in another room. But putting that together with my insistence on a hearing does mean that the victim needs to be able to be observed by the hearing panel. And they need to be able to ask questions. I think it could work to submit, that the attorneys submit questions in writing to the hearing panel and the chair reads the question. So it's not as threatening, maybe even rewords it. But in that case in San Diego, that just went all way too far. I mean, the chair just didn't read any of the questions, right? And so, that's a difficult call. So some form of asking questions, not the same as the confrontational form that we use in a criminal trial.
The only thing I would add to that is I have seen several cases where one party has had a hearing and the other doesn't, whether it's the complainant has one and the respondent doesn't, or vice versa, and they are quite a challenge because we're trying to make this fair and balanced. One person has the, attorneys are expensive, and other than perhaps Harvard Law School, which will help pay for an attorney for the parties, most colleges can't afford to do that. So if one party can afford to get an attorney and the other can't, then for all the reasons you said about an attorney providing advice and being able to frame the issues, understand what the legal issues are, the unrepresented party doesn't have those opportunities, doesn't have that advantage. I've also seen some cases where there was an attorney on one side and a law student on the other, and invariably the party who's represented by the law student gets creamed because the law student doesn't have the same level of skill as the attorney on the other side. So that's a challenge for a lot of schools, and including at the schools I've worked at, trying to figure out what you can do in a situation where one party has an attorney and the other doesn't, to try and balance the process and make sure that the unrepresented party doesn't get overwhelmed.
Do I get to say anything again? I just
Really
wanted to
quickly.
interject that maybe it's Ithaca, New York, but I've seen some hearings in which a trained law student walked all over the attorney.
There you go. Better law school, perhaps. I don't know.
Professor Bowman, one concern is that the accused have faced a lack of due process. Knowing the steps that have already been taken to combat sexual misconduct while protecting the rights of the accused, what else should be done?
Oh, gosh, all kinds of things. And I'm sure that we're going to agree on most of these, too. I mean, I think there should be mandatory orientations about sexual assault, which still doesn't obtain at a lot of places. I think there should be educational outreach to fraternities and sororities. I think when I was chair of the board, these decisions were all secret. They're confidential. And so I was developing this kind of, as an old appellate court clerk, I was writing decisions and I wanted the news of my jurisprudence to get out. And so I wrote an article for the student newspaper and I went on the student radio show because I was trying to get across, hey, drink and have sex at your own risk, right? And your risk can be very high. And make sure you get consent. That consent at every stage is very important. So educational, certainly educational, all kinds of educational things that we could think of. What else? I'm stepping outside the legal framework. I mean, this obviously college is too late for a lot of these students. You got to move it back into the high school, maybe into the grade school these days. I don't think we can stop them from drinking that much. We've tried. I'd like to hear what you come up with as ideas.
It's what you said. I absolutely agree. Education and prevention has to be where we're at. It's not uncommon for So at one school I worked at several. At one school I worked at, the Women's Center, which was a confidential place where, despite the name, Women's Center, both women and men, any gender identity could go for support and counseling for sexual harassment and sexual assault. They received between 200 and 300 reports a year, and confidential. Because they were confidential counselors, they didn't have to do anything with it. They didn't have to further report it. But only maybe a half a dozen of those individuals eventually made a formal complaint. So it's happening on campus a lot, and the grievance procedures, we're talking about them a lot, but we're really talking about a minority of the cases of sexual assault that happen on the campus. We have to do something more to let our students know that this kind of behavior isn't tolerated and needs to be, and isn't appropriate. And the way we are doing it, the way schools are doing it, are just what you said: education, orientation. The first 6 to 10 weeks of college are called the red zone, because the majority of sexual assaults, particularly for first-year students, happen during that period for obvious reasons: unfamiliarity with alcohol, with personal freedom, perhaps with sex as well. And so we need to reach the students as early as possible. We need to have ongoing awareness campaigns. Many schools are using bystander intervention programs as a preventive measure. So it's not just education, but it's prevention. It's taking care of each other. It's taking a pledge to protect the members of your own community. So there's that. And then, yes, the response system is part of it. Letting students know that there is accountability. But I really do think, as you said, we've got to dip back into high school and middle school, and even in elementary school, about personal respect and boundaries and all that. It's a cultural change. And when there's so much in the media that glorifies sex, that glorifies alcohol consumption, all that, colleges are really just a small part of this issue, and we come to the party fairly late, and maybe colleges can do more to work with shifting the culture than may have happened in the past.
It's interesting because there was recently an article that said, among other things, that the percentage of sexual assaults against women in this age group outside of college is in fact higher than that on college campuses. So at least on college campuses, we're trying to do something about it. And the person isn't given the stark choice of go to the police, go to the criminal court, or do nothing, because we have other alternative procedures. I guess I would add that the new regulations, as I understand them, also require training of all of us in a sense. And so that one of the things my colleagues are really concerned about is, are we all mandated reporters? And this is a real sticky point, because somebody comes to you in confidence, and in particular, if you're an attorney, if somebody comes in and says, "I'm telling you this in confidence," and yet formally you might be required to report it up in the Title IX structure. Are you?
Depends on the school, it depends on its own policies. What Cynthia is talking about is OCR has said, and the law says, that once a school knows about possible sexual harassment, sexual violence, then the school has a responsibility, at least, to do something about it, to respond immediately and appropriately. So what does that mean, knowing? Who at the university is in a position to know and take on that burden for the university? At one school I worked at, they defined it basically to about 800 people by the nature of their jobs. These were deans, department chairs, supervisors, managers, individuals with significant responsibility for student or campus activities and well-being. At Duke University, everyone is. The language we use is all employees are expected to report. And that is faculty, staff, maintenance people, everybody. And so if that's because we want to cast a wide net. We want to find out about these instances. If we're going to accord ourselves that level of responsibility and accountability, we better make sure that the people that we've given that responsibility to know how to report it. So we've done this massive training. We have 40,000 employees at Duke, between our university and our health system. Imagine training 40,000 employees. It's got to be online, and we aren't quite where we finished yet. But other schools I know, for a variety of reasons, have a much narrower view of who a responsible employee is, in part to avoid opening up the doors to liability when that professor does find out about it and is a close friend with the student and doesn't want to violate that request for confidentiality. Not what you asked at all, but hopefully of interest.
I think we have time for one more question from our student panel. Mr. Williams, if you'd like to ask another one.
Just addressed to Mr. Kallem. As you know, the proposed Safe Campus Act will require the victims to report to police any sexual assault before requesting a campus disciplinary hearing. It also grants both the accuser and the accused the right to hire a lawyer. What are the potential consequences for the victims and accused due to this act?
I think that the Safe Campus Act is horrible. I think that the Fair Campus Act is better, but still horrible. So, you've been sexually assaulted. You've lost control of a significant portion of your life. And, you know, you're trying to go on with your education and your life, and you can't because this person has come into your life and has deprived you of your free will. So now, forcing you, as unpleasant as a campus disciplinary proceeding can be, where you have to tell your story several times to several different people and, you know, probably go through a hearing and all that entails, going through a police investigation and a criminal trial is even harsher to deal with. So by requiring that the matter be handled by the police, be reported to the police before the university can even do, and if it's not, the university can't do an investigation at all, you're further depriving the survivor of control over what happens to them. And I think that's just terrible. I think that both the Safe Campus Act and the Fair Campus Act really are all about protections for the respondent, while they have a few, you know, cursory provisions on education and prevention. They're really trying to force this into the criminal arena, which has where it's harder to prove violations. And again, I'll ask, what is it about sexual assault, sexual violence, that prompts this kind of response when nobody has proposed having the same kind of mechanism, getting the police involved for theft, for physical assault, for racial hate crimes, and anything else, just for sexual assault? I would venture it's because sexual assault disproportionately affects women. I think that there's an unfounded belief that many of the reports of sexual assault are false reports, and I think that this reflects a societal bias against women, but that's just my own feeling. For the procedural fairness requirements issues in both of these laws, there are some good provisions there, but again, I think that it talks about the opportunity to safely confront witnesses, including the complainant. The opportunity to safely confront witnesses, including the complainant. Doesn't say anything about the opportunity to confront the respondent. It's just the complainant. That reflects the law's emphasis on procedural protections just for the respondent. It says that there's judicial review of the decision by the university only for responding parties under an arbitrary and capricious standard. It doesn't provide for any review for a decision by, you know, a request for judicial review by the reporting student or the complainant. It's a biased law. It has some good provisions in it. I think that, and I think many of the provisions that are good that are in it are already being done by many schools. So I really do think that it's a stretch. It's an attempt by people who have the respondents' interests at heart to try and counter the pressure that's being presented to really have fair and balanced proceedings.
I agree and I disagree. I think we both agree that the Safe Campus Act probably was designed by people who don't particularly favor giving remedies for sexual assault. That whenever somebody puts a provision in there that you can't get any kind of remedy unless you're willing to go to the police, who will be hostile, and then go through a court proceeding, which is going to be grueling, that your alternative is nothing, they're basically counseling nothing, right? That's the reason it's in this act. But it's not in this act, okay? This is the Fair Campus Act, right? It's been taken out. And I do support the procedural protections that are given to defendants in this act, and as to all of them, if they don't apply to both parties, would have them apply to both parties. I think it's kind of the nature of public policy in the United States that it does these immense swings, you
yes,
know?
absolutely.
Here's a problem, woof, okay? And then you get this objections, and then you go all the way in the other direction. I mean, we need an act that combines this with the Dear Colleague letter or something like that, you know, that takes both of them. But the point was that if you read the Dear Colleague letter, it doesn't talk about respondents' rights at all either. It's just as one-sided. And so I think there needed to be people saying, hey, you've left this out, and that's why we are where we are. Hopefully we're still going further.
But if you read the 2001 OCR guidance, which is the foundational document for the Dear Colleague letter, it does, again, I have the language somewhere, but it does say that providing due process, recognizing the due process rights of the accused student, recognizing the due process rights of both students is the best way to achieve a sound and supportable outcome. So I can say that because I helped write
You wrote it.
guidance.
And you were gone by the time the Dear Colleague letter was written.
No, I was there, but they didn't ask me.
Okay.
So there is that. I do think that there is a great need for additional guidance and not sub-regulatory guidance. I think that whether it's through regulations or additional legal guidance, I think colleges and universities need sound, practical instructions on how to develop systems that can be tailored to their own particular campuses, while at the same time making sure that we're providing a consistent process, regardless of the context.
So in part, maybe this DOJ grant, and also the ALI has set up a task force on which I sit. And so there are people out there trying to say, hey, let's not do this all in such a big hurry. Let's think the whole issue through. And particularly, for like small colleges, how do they, they don't have a law school, they don't have law students. How are they going to work some of these systems? The Harvard law system, when you look at it, looks great, but they're going to go out and pay for every student to have a lawyer to represent him or her. The small rural liberal arts college still has to deal with these questions, but under considerable more constraints.
Or the community college, which
the community college,
and so I think that's absolutely right. To look at the system that the Harvard law set up, it really is not a sustainable model for many schools. One of the criticisms of the Harvard law school was that it took away authority to handle these cases from the various schools at Harvard University. Well, the law school might very well have people who know enough about Title IX and trauma and all that to be able to handle these cases. But the engineering school, how do you train people there to handle this entirely on their own? The nursing school, probably not. So we are in need of a more sustainable model, whether it's the single investigator, hearing, or hybrid model.
I thought it was a little bizarre that the Department of Education allowed one part of the university to have a separate procedure instead of saying, if these are good procedures, why don't you talk to your colleagues and adopt something similar that'll extend to the whole university?
Political. They didn't want to get that fight.
Thank you both. The speakers will now accept questions from the audience. We have two students holding mics, so hold up your hands so they see you. Please keep your questions very brief so we can get as many questions in as possible.
At Case Western, students are all non-confidential sources. So my question goes to both of you, asking, do you believe it is right to make peers non-confidential sources for students who have been sexually assaulted?
What's that mean?
So I think what you're saying, if I understand you correctly, is that students at Case Western, if they find out that somebody else has been sexually assaulted, they are expected or required to report that? That's interesting. I don't know that I want to necessarily criticize what another institution is doing. That I think is fairly unusual. I would think that one reason why you're doing that, the school is doing that, again, they want to cast a wide net. They want to make sure that if something happens that could be a violation of their disciplinary code, that they want to be able to find out about it. For two reasons. One, because maybe they need to, initiate discipline. But the other reason, and really what at bottom is why we're doing all this is, if somebody's been sexually assaulted, our immediate concern isn't necessarily finding the perpetrator and taking them to a hearing or investigation. Our immediate concern is for safety for the student, for the survivor, getting them to the hospital, getting them to counseling, getting them the accommodations and supports and measures. They were sexually assaulted on Wednesday and they have an exam on Friday. They need to get excused from that exam. They're living in the dorm, on the same floor as the accused student. Giving the students, the opportunity to move to a different dorm. Those are all good reasons, I think, why a school might want to cast a wide net and do what it can to find out about it. The flip side of that is it could just, if students know, hey, if I talk to my best friend about this, he's gonna have to tell somebody in authority about it. It could chill or discourage those conversations and prevent somebody from getting referred to the places of support that they really need to get. So I think that it's a balance that a school has to set for itself.
I must admit my own response was just like sort of personal, to put myself in that situation and think that, my God, if you come back from having a horrible sexual experience, you can't even talk to your roommate,
Yeah.
right? I mean, what it could be is just silence everybody, and certainly from a reparative standpoint, you want people to be able to start to talk about these issues and talk with their roommate, what was just happened? Was it assault? Was it sex? Was it rape? What was it, right? And be able to cry and get upset. But it strikes me that rule would be very counterproductive in that way.
Thanks.
Well, this question, I think, since Mr. Kallem did most of the last one, we'll go to Professor Bowman. How do you think the link between highway funding and a 21-year-old drinking age contributes to campus sexual assaults?
I mean, I take
So that was a question for her, right? Yeah.
Just wanted to duck that one, right? I mean, I take it your question is really one about the connection between drinking and sex. Drinking and driving, of course, as well, but the requirement is attached to the driving law for other purposes. I think that there is a large connection between consumption of alcohol and sexual offenses on campus. I don't know if I would go about it through the highway bill. Universities, have been struggling with this problem for a long time. Attempting, all of them say there's, alcohol's not permitted in any fraternity house at Cornell. Is it prohibited at Duke too?
We do allow it.
Oh, you allow it.
But we have some mechanisms which I can talk about to
try and make it
it.
safer. Well, that hasn't helped. So now, I mean, it's almost things like making it safe for somebody who has violated the campus code to come forward knowing that they won't themselves be accused of a code violation. What I mean by that is, and one of the things that the Fair Campus Act does is it has an amnesty. If you come forward and say, we were all drinking and that's prohibited, right? And I was there and this is what I saw. It says you are immune from prosecution of any sort for the fact that you admitted that you were breaking the law. So, I mean, at Cornell, where we are is sort of making sure that people aren't scared to come forward when somebody is dying in the upstairs room. They need to know that you need to take the person to the hospital, even if your fraternity gets decertified as a result, right? So you got it, when you think about these kinds of incentives, it really expands, and it's kind of, it's difficult.
Yeah, the only thing I can add is that colleges have been, as you said, colleges have been trying to deal with drinking issues for years, and states have as well. When I was a kid, 18 was the, law, and it just drove drinking underground, but it still happened. So 21, maybe different. What we do at our schools, we have party monitors. If you're going to have a party, whether it's a fraternity or anybody else, and you're going to have alcohol, you have to have at least one or more people designated as party monitors. It's sort of like the designated driver. They'll remain sober. They'll make sure that nothing gets spiked. They'll watch for people getting in trouble, getting drunk and all that. Does it work? Sometimes.
Do they rotate the job, or does that person just become the hated person on campus?
Yeah, no, they do rotate it. Every organization has to have a certain number depending on the size of their organization. So that's one way to try and deal with the issue. But like Cynthia said, so many of these incidents involve alcohol by one or both parties, either taken voluntarily or used as a weapon, and it's a tough issue.
My question is a simple one, but I'd like to just briefly contextualize it. So we have Professor Bowman at Cornell, yourself, Mr. Kallem, at Duke, and then we're talking about Harvard, we're talking about this university, and how the autonomy of these universities to have their own procedures, their own policies, their own ways of whether there's a hearing, there's not a hearing. You've both seen it both ways. You've seen it with lawyers, you've seen it without lawyers, to you asking each other questions. How does that work, My question is this: is this just one big trial and error process, or is there a way to at least have something concrete here? So everything we've discussed here and heard has been quite abstract, and the procedures seem to be airy at that in terms of what is an underlying cause. Now, we all seem to agree that the sexual assault is real, violence, it's real, it's a problem, that there's a culture change needed. First of all, who gets to decide that? But that's another question. The question I'm asking is, with Title IX and with sexual assault on campuses, should there be an underlying minimum, shall we speak, in procedures and policies? And then who gets to decide that? Is that our lawmakers? Is that professors? Is that people of a government agency?
Well, there certainly, in my opinion, should be a minimum. And there's various items of procedural fairness about which the two of us would disagree. I think right now there's kind of an attempt to capture the federal government to figure out which of those are going to be mandated. In my own institution, I thought the procedures were working pretty well, right? And we developed our own sort of procedurally fair, and I was very upset at the Department of Education for intervening and saying to us, you've got to change your standard of review. And wait a minute, we're using this, it's work, it's the one, who are you to tell us we have to change our standard of review? Now, it's interesting because at that point, when I'm arguing with the General Counsel's office, that whole question of, oh, they're intervening in our autonomy, that didn't come up, all right? But now Governor Cuomo has just passed this affirmative consent bill in New York State, which basically changes instead the substantive law, saying, you know, at every stage of the interaction, you have to make sure you have affirmative consent. They're up in arms. They're saying, how dare he tell us that? How dare he change our substantive law? And I'm thinking, where were you back when, you know, the Department of Education was telling us we couldn't have hearings the way we used to have them? So what is that? I mean, did I just take a big stand for the autonomy of elite institutions? I didn't mean to, okay? But I think that there are some ways in which there's obviously going to have to be a period of experimentation and study, and I think it would be a mistake to bring it to closure too quickly before we really see what's going to work. Do I have confidence that's what will happen, or it'll just be the result of political balance of power?
And meanwhile, we're getting more cases that are, and complaints that are being filed that we have to respond to. What will work for a community college might not be appropriate for a four-year residential college or for a large university, or vice versa. Different resources. When you're dealing with a residential community population, that raises a whole different set of issues than when you're dealing with commuters. The community college students are non-traditional, they're older. Different procedures might be appropriate for them. What might be appropriate for a large public institution might not be appropriate for a small religious institution. You do, I think, have to give some flexibility to schools to reflect their culture, their mission, their purpose, you know, what they look like, how, if they're decentralized, or at Duke until recently, every school handled, you know, the engineering school, the environmental school, they handled these matters separately. And, you know, there wasn't a lot of consistency, and it was difficult to get people trained. So last year we brought them all in for both graduate and undergraduate students into one process. There was some kicking and fussing, but not too much. That might work for us. Other schools that are, you know, decentralized, you know, Duke is a relatively small, you know, with 6,000 undergraduates and 7,000 graduate students. UNC Chapel Hill is 30,000 students, you know, so different. There has to be some room for some flexibility. I do agree, though, that there has to be some core elements of fairness, procedural fairness, or due process, depending on the institution. Perhaps more for publics than privates, but again, you know, we want our procedures to be fair and balanced. Also, keep in mind that when we're talking about sexual misconduct here, we're not just talking about sexual assault. We're talking about, you know, unwelcome requests for sexual favors and graffiti and other forms of unwelcome conduct of a sexual nature. And, you know, so a one-size-fits-all approach might not be appropriate for every type of violation. So there's got to be some flexibility. I do think that, you know, having worked in the federal government for 30 plus years, I'm a little bit more comfortable perhaps to see federal involvement in this and setting, and the federal government setting minimum requirements. I do think that OCR didn't go about the guidance it did issue in the best possible way. It should have done a better job of getting input from universities. As a result, some of its guidance isn't particularly practical. I still think there's time for that.
You know, this whole issue of the public and the private, it's interesting because it ends up, Howie Kallem has been at both, right, the University of North Carolina and at Duke, and of course at UNC, you get a lot more procedural protections, right? And there's all kinds of things that are different. I mean, a public university faculty can look up what everybody makes and know comparative salaries. You know, there's these various things that are based on the fact that the state is, I guess, paying. Now, so at Cornell, this has led to this kind of ironic thing where Cornell, you know, was originally, part of it was a land grant college under the Morrill Act back in the 1860s, right? So we have the endowed colleges and the land grant colleges. And the university administration takes the position that we're all private because of that. And some of the law professors who teach education law take the position, no, we're all public because of that, you know? And you can see why, because the administration doesn't want to have all of those requirements. But when it comes to these things, you know, I just think, what self-respecting university doesn't want to treat its students with procedural fairness, right? Whether they're partly funded by the state, as all are really, or private, right?
So if the federal government has the ability to pull funding in an infraction of Title IX, and sexual misconduct is such, you know, a rampant problem on college campuses, why hasn't it? Is it an issue that the college campuses are doing things, they're just not particularly effective yet? Or is it an issue that there's no follow through on behalf of the government?
I'll give you my perspective on that. And the official OCR line is that that when there is an investigation and OCR comes out with a resolution agreement and makes findings of violations, the schools are fixing them. They're addressing the problems. They may not address those problems without that threat being there, and it may take some negotiation and some time, but in the end, they're signing settlement agreements, resolution agreements, that bring them into compliance. So if they're coming into compliance, then there's no need to cut their federal funds. There have been cases over the years, not on sexual harassment, but on other issues and other laws that OCR enforces, where that administrative enforcement mechanism of cutting off of federal funds that process has begun because schools have resisted, but as a general matter, they never go full to the end because at some point the school just throws up its hands and says, we'll do it. So the Assistant Secretary for Civil Rights, when asked if she thought that the agency should be giving the right to fine schools instead of cutting off federal funds, said that the agency didn't need it because they could get compliance through the threat of fund termination. I think that's largely true, and I'll just leave it at that. No comment?
I don't have anything to comment on that.
Mm-hmm.
Hi. So for any society, implementing a system of justice that's competent and fair and believed in by the community is one of the most monumental, difficult tasks it faces. And I wonder if you think it's realistic to expect or ask each and every college and university to develop a system of justice that's competent to address this problem, or whether there's a different approach that might be more effective in attacking this problem.
Well,
yes.
Yes, I mean, I think many of us are hoping for that. I mean, it's one of the reasons why I'm going to cancel classes and go and work at the ALI for a couple of days in New York, you know? I mean, it seems as though if some model procedures could be worked out, that eventually we got assent to, or even had to test them in court at some point, that would be fine. But I mean, I agree. I mean, my own alma mater as a college student was very small, and they got sued and they reached a consent settlement, and I mean, they don't have lawyers, and how are they going to run their hearing board and all of that? So they just reached out to, they've got alums who are retired judges, right? Somebody come and help us out here. And so now, you know, a retired Swarthmore alum is running their hearing board. But yeah, I mean, you're right.
But what I'd add is they've done it already. Colleges have had student codes of conduct from the moment they open their doors. And again, what is it about sexual assault that's different than physical assault or racial hate crimes or any of the other? I mean, what is it about this issue that has caused this uproar when you don't quite see it as to many of these other types of student misconduct? and they've been addressed through the student disciplinary codes forever. And you don't see the, oh, it should be handled criminally and all that with those, those kinds of issues as well. It's just this issue. It's very puzzling.
Considering hearsay is usually inadmissible in court, is it fair to find a party liable solely based off of hearsay evidence, especially when the standard of proof is simply preponderance of the evidence?
No, it's not. I mean, the hearsay that I would think of in this respect would be in these, the Cornell procedures are in the process of being revised. But in the procedures that have been in place right now, this investigative report is what is given to a panel. Well, what is this panel? What is a hearing that's based on being handed a written report? Huh? I mean, that was an issue in the San Diego case as well. It's hearsay, right? And unless you can cross-examine the person who wrote the report, but that's still hearsay upon hearsay, right? So I don't think that unless you can supplement that with live witnesses and have the author of the report there to be cross-examined, that you've got any modicum of due process.
Okay, so hearsay applies in criminal proceedings. It's generally excluded. This isn't a criminal proceeding. Nobody's going to jail as a result of a, Case Western Reserve student conduct proceeding. There are reasons why schools don't use that hearsay rule. Sexual assault is often word against word, and it's very hard to prove, and so very few cases are criminally prosecuted, and so very few of those are result in convictions, in part because they are the hearsay exclusions. So schools intentionally can use information that wouldn't stand up in a criminal proceeding. But I agree with you. Do an investigation, share the investigation information with the other party, give them the opportunity to challenge that, show each party the statements of the witnesses that were there. I think it's in many cases, if not most, you're not going to make a finding of responsibility strictly on hearsay evidence. You're going to have other information as well that will help tilt the balance. And, it depends on who you talk to. If you talk to respondents, schools are just routinely finding responding students, responding parties responsible. And they're just, trampling their rights, and everyone who goes before a hearing or investigation is going to get kicked out of school. You talk to the reporting students, and, nobody's getting found responsible. And the truth is in the middle. There are cases where students are found responsible, and there are cases where they aren't. And there will be those cases where, using that preponderance more likely than not standard, you just can't meet it even with the more flexible rules. And that's the nature of the beast. That's how the process has to work. And, and somebody's going to be unhappy, and every school is one headline away from an OCR investigation. It's just how it's the cost of doing business for us.
I'd like to direct a question, especially to Mr. Kallem, in the sense that you brought up the interface between universities and fraternities and surveillance, participation in parties, whatever you want to call it.
Yes,
so it seems to me there's a jurisdiction within a jurisdiction issue here, or four of them: federal, state, college, and fraternity. And in the public view, fraternities often serve as a shelter for bad behavior. Now, obviously, that's not the entire truth, but I wonder if both of you would like to make some more inclusive comments about the value of fraternities, the extent to which they pose a central issue, because group psychology, I think, is at the heart of an enormous amount of sexual misbehavior, and the closed roof above you encourages conformity to that group.
So there are some groups on campus who are, more often than other groups, accused of sexual misconduct. You don't see a whole lot of accusations being levied against members of the chess club. But you do against fraternity members, athletes, whether rightly or wrongly. They're visible, they have high visibility positions on campus that might give them some power over other students that might enable them to accomplish sexual assault, but it also might put them in a position of being targets of accusations that may not be, supportable or justified. I do think you have a really good point about that sort of herd behavior, groupthink, and that if you've got a bunch of bad boys together, they can, or even just boys together, and I'm using boys deliberately, and they can sort of feed on each other and wind up, hanging posters out, bed sheets outside their fraternity window saying, parents, drop your daughter off here, and that sort of, the kind of, they just don't think. They just don't think. These kids, and I was an 18-year-old boy myself once, and I didn't think, and I still don't that often. But so really important that schools work with their fraternities and athletes to let them know that they are in a highly visible position, and with that visibility comes responsibility. So that they need to monitor their behavior, perhaps even more so than any other student on campus, and to enlist them as allies in this. I know the fraternities on our campus, they are developed, and at UNC Chapel Hill, they've already done this. The fraternities on our campus are coming up with a requirement among their interfraternity council that every member is going to have to participate in bystander intervention training, which talks about what sexual assault is and how to prevent it and how to help each other out. And we provide special training to our athletes as well to help them monitor their own behavior, as well as to help them, again, make them allies in combating it. I think that there are some efforts at the national level with fraternities that are trying to do more in terms of educating their members, that there are also some maybe less productive efforts, like some of the legislation that they're supporting. But fraternities can be and sororities can be a tremendously valuable resource to students and on campus. They do many fraternities. It's not just about drinking and partying. They do a lot of community activities, and they do take leadership roles on campus. And schools want to continue to promote that, while at the same time, monitoring their behavior and making sure that they are treated the same in terms of compliance as any other student.
I don't want to defend fraternities. And one of the things about these two acts is that actually fraternities are obviously one of the interest groups that are involved in those bills, because they also have sections that try to protect them against universities and being decertified in these kinds of circumstances. So
yeah, there was one school that, as an initial response to all the bad behavior that it thought its fraternity were engaging in, was going to require them to admit women. And so that got a lot of attention. And
so they have single-sex.
And that school since backed off. But yeah, that.
But these acts have, Title IX does not mean that you have to admit two sexes to a fraternal organization.
And the OCR regulations already recognize that anyway. But
I think we have time for about one more question.
I would have thought it was time for closing.
Okay. So the red light is on. Okay. So I've been a little puzzled by the statement that it is puzzling that this particular form of behavior gets special attention and is treated differently. Because it would seem to me that there's two reasons it's being treated differently. One is that people are not embarrassed necessarily, they are sometimes, to report being robbed or otherwise abused. Whereas, as we all know, there are some social pressures involved in admitting rape or other sexual violation. And the second reason why it's a separate issue is because the OCR issued a guidance letter about it. Since the OCR issued a guidance letter about it, it's being treated separately, and the university general counsels are are responding and so on. So unless there was no reason for the OCR to issue a guidance letter about it, I don't see a puzzle. And so I'm just wondering if perhaps you would both like to comment on the extent to which this is a particular issue that does have particular difficulties that require perhaps some particularly different procedures.
So let me see if I can clarify what I intended by that remark. The disciplinary consequences for students from sexual harassment or sexual assault can be the same as disciplinary consequences from physical assault or racial harassment or theft or any other thing. You don't quite hear complaints and pressure from students and advocacy groups for the same sorts of procedural protections for respondents in those other kinds of cases that you hear for cases involving sexual assault. You're not seeing legislation that says in cases of physical assault, the respondents should have the right to an attorney and a hearing and 17 steps of protections. People are only saying that in support of respondents in sexual assault, sexual harassment, actually just in sexual assault cases. So that's where I see, that's the puzzling part to me. Now, it's really not puzzling to me. I do think it's because of the societal and cultural prejudice against survivors, against people who report sexual assault. They're not believed. And it's this belief in false reports, and that, boys make mistakes and all that. And I think that's why there is that difference. I do think there are some reasons why some of these procedures should be different, particularly for the reporting student side, but for both. In some of these cases, you have to deal with the impact of trauma on a survivor that you wouldn't have in the theft of a wallet situation. So there is, in these procedures, a need for some different types of expertise and that you wouldn't find in some other student disciplinary cases. So in some cases, I do think these need to be treated differently than other types of student misconduct cases, particularly when it comes to understanding what might have happened and understanding all the complications that can arise that wouldn't happen in some other cases. But for me, the puzzling part that really isn't puzzling is all this outcry on behalf of respondents that you don't see for other types of misconduct they're accused of.
Well, I can tell you that the reason they were taken out of the Cornell procedures, which all operated under a fairly adversarial system and the clear and convincing evidence standard, was that the general counsel told us that we couldn't possibly run through the same procedures people who were going to be judged on the preponderance of the evidence. That because it was going to be a different standard, we needed totally different avenue. So I'm agreeing with you that there, at least, it came out of the OCR letter. At the same time, one of the women law professors who was at the White House meeting with me said, I've never seen my colleagues so worried about due process protections before. And this is a woman who's very concerned with issues having to do with incarceration and people of color, et cetera. And suddenly her male colleagues were really upset about due process protections. Here, you should hear that I'm sort of agreeing with you, Howie, so be sure and listen. That I think men are afraid that they'll get accused of something, and they, that a lot of the procedural protections they want have to do with that. But I think we should have them for everybody and for all different kinds of offenses, because whenever you got a sanction that's serious, you need to be really pretty sure about your facts. And you've made several comments about this is part of this whole continuum, sexual harassment to sexual assault. And, that continuum isn't all criminal, it's partly civil. If you get sexually harassed, it would be a civil action, not a criminal action. So we have them kind of both merged in here together. Do you want us to do our closing step? I'm getting tired of standing up. You want me to start?
Sure.
Oh, okay, all right. Okay, well, I think there's a kind of contract between universities and their students, and some authorities have located in the student handbook, and it involves an obligation to treat students with basic fairness. And indeed, as universities and as law schools, we should model the procedures that we are convinced and that have come to be embraced by our legal system as indicia of fairness. And that, in my mind, involves a hearing, a neutral fact finder, and the opportunity to question the witnesses and other evidence before you. Now, a hearing of some sort is necessary. A colleague of mine and I who got called over to the administrative powers that be to explain our objections, would often on the way over talk, what's our bottom line? What's our bottom line? And he kept saying, preponderance, the evidence versus clear and convincing. And I kept saying, no, a hearing, a hearing. You have to have a hearing. And our legal tradition associates accuracy of fact-finding with an adversarial hearing. But a hearing doesn't have to be that adversarial, and it serves other purposes as well. Indeed, it's associated with a kind of dignity interest, right? The right to be heard, the right to tell one's story. And that requires testimony from live witnesses, not just a paper record. The hearing needs to take place before a neutral fact finder, not an administrative official who's been charged with Title IX compliance. With all due respect, this new profession of Title IX compliance officers have a particular bias, right? Compliance with Title IX, compliance with the law, but they're focused on that particular area. And so beyond separating the investigative and prosecutorial functions from adjudication, I think you need a genuinely neutral fact finder, panel, hearing panel, which I have found in the past students, faculty and staff do very well. Now, my hesitation over using the word student is that there's a lot of controversy on my campus among women's groups about whether they want students to be on these panels. And many of them don't, and it's largely for privacy reasons. So I was kind of surprised because at the same time they're telling us, you're a bunch of old fogies and you don't understand the mores of my generation. I was coming to as I listened to their tales. But they say, well, give me an expert witness then. Bring somebody in to tell me all about hooking up and how much drinking is just a little drinking and stuff. All students accused of sexual offenses should have a right to confront the witnesses against them. This isn't the same as the Sixth Amendment right of confrontation. It's fine with me if it's in a separate room and questions are transmitted in writing. But the panel should not be asked to decide on the basis of a written report by an administrative official. The decision of the panel must be that of the panel itself, not an endorsement of conclusions that were previously reached prior to the hearing. Thus, any sort of report admitted into evidence, the official who wrote it has to be there to be cross-examined. And the parties must be able to have access to the report and to supplement it with live witnesses. I believe, and we've developed this point probably enough, that both parties should be entitled to legal representation throughout the proceedings. At bottom, accused and accuser must be treated the same in that respect. It needs to be equal. And I don't think there's any way we're going to require a victim to pursue her claim on her own. Okay, see, I made those points already. The standard of proof. What's the big difference between these two? Well, the preponderance of the evidence standard means that if there's a smidgen more evidence in favor of one side, that side prevails, right? The equipoise tip. So if the case comes down to he said, she said, and the plaintiff seems slightly more believable, credible, she wins. And although liberty is not at stake, as I've said, the stakes are extremely high. Getting expelled from college is something that, if that has been done based on an inaccurate fact finding, or because you were nervous and she wasn't, or in some way the credibility was judged that was incorrect, that's a tragedy for the rest of that person's life. So what is the clear and convincing standard? I think of it as we need to be pretty sure, right? That before we impose a serious sanction, we need to be pretty sure. Clear and convincing. I guess one thing we didn't really even discuss at all is that I don't think we should ever proceed in a sexual assault case against the wishes of the victim. I think this amounts to disempowering someone who's already been disempowered. Mr. Kallem talked about this in the context of forcing them to go into a criminal proceeding, but I think it applies to a campus proceeding as well. I think we should give the victim lots of support and encourage her to proceed, but if she decides not to, I think we need to respect her reasons. She may have many reasons, and we need to respect her judgment. Thanks.
Okay, so I don't have any particular stake in any particular investigative or adjudicative model, but I do want to defend the pure single investigator, pure investigative model and show why it could well work. Again, due process, as interpreted by the Supreme Court, requires notice of the charges, disclosure or explanation of evidence, and an opportunity to be heard to challenge the evidence. And I think you can get that through an investigative model. One of the most frequent criticisms of campus sexual misconduct proceedings is that the individuals involved don't have the training and experience necessary for such a potentially complex task. One commentator wrote, in the nationwide controversy over the proper response to pervasive sexual assault on college campuses, there is one thing almost everyone agrees on. School disciplinary boards have rarely done a very good job of handling these cases. That's partly because these boards were never intended to try serious crimes. Composed of faculty, administrators, and sometimes students, they were originally created to handle honor code violations like plagiarism and underage drinking. Their members generally don't have training in law, investigation, or the use of physical evidence. There are rarely hard and fast rules about what sort of information is and isn't admissible, yet due to a combination of law enforcement failure and federal regulation, they are on the front lines of the campus rape crisis. It is a challenge when you're working with faculty and staff and students to keep them trained, to get them to the point where they can handle the issues that can be so complex in dealing with the impact of trauma, in dealing with word against word situations, in dealing with the impact of alcohol. With a single investigator, you don't have to deal with that. You have one person, it's not really one person, but you have one person who is a trained professional. They have the experience, they have the training on how to do all these things. It's also quicker. It's not a multi-step proceeding, and one of the criticisms that we get is these cases take too long from both sides, and a single investigation step can be much quicker. And you can do it in a way that meets those basic elements of due process: notice of charges, disclosure or explanation of evidence, opportunity to be heard, and particularly if you have an appeals procedure to somebody else, then there is that independent review. Most employers, including colleges and universities, handle employment discrimination complaints, including sexual misconduct, sexual violence complaints, in just this very way. They have one investigator who does the investigation and make the decision. With all due respect to you students here, why are you so different? If an employee gets fired because they raped somebody, just as serious consequences for them as a student who might get expelled. So again, I'm not entirely sure of the difference here. I think that the other issue I'd want to address is the preponderance standard. And Title IX is a civil rights statute. It's not a criminal statute. This is a standard that is used in all employment, in all discrimination cases under Title IX, Title VI, Title VII, which deals with employment discrimination, Americans with Disabilities Act. If a student accuses a professor of giving them a bad grade because of their race, or accuses a professor of failing to provide an approved accommodation for their disability, should that be handled under a clear and convincing standard? It's a civil rights matter. No, a court and OCR will view that under a preponderance standard. If a fraternity is accused of refusing to admit a student because he's black, because he's African American, should that be handled under a clear and convincing standard in court through a school's grievance procedures? No, it should be handled under a preponderance standard. It's a civil rights statute. All these kinds of accusations can have just as serious consequences for the accused as a sexual misconduct, a sexual assault allegation. And in civil cases, where, you may not be old enough to remember the O.J. Simpson case. He was accused of murder. He was acquitted in criminal court. They went to civil court. He was found liable for that, multi-million-dollar damages that he had to pay, and it was a preponderance standard. Again, this is how most employers, including colleges and universities, do handle their employment discrimination complaints. Single investigator, preponderance standard, at least for staff. Maybe for faculty it can be different. The last point I'll make, and you may have misunderstood what I said, I wasn't talking about proceeding against the wishes of the victim. We've had cases where the survivor wants to participate, has gotten through the investigation, now we're getting ready for the hearing, they decide it's going to be too traumatic for them to confront their accuser, to be in the same room, to hear them. And what many universities do in that case is if they've got enough information to really strongly suggest the possibility of a policy violation, then they will go forward with the hearing without the complainant. Does deny the responding party the opportunity to directly ask questions of the complainant, but you've got an investigative report, you've got the investigator in the room who can talk about what the complainant, the reporting student, told them and give the responding student the opportunity to challenge that. There may be some cases where the complainant doesn't want to go forward. It's the third case of rape reported against the same responding student. In each case, the complaining student is too afraid to go forward. The respondent has done such a good job of intimidating them that OCR has said, there may be some situations, though rare, where because of the greater obligation to protect the safety of the community, then you may want to go forward with an investigation, even though the 3 or 4 victims, survivors, don't want you to do that. It's rare. It could have a chilling effect on others coming forward, knowing that might happen. So it's a difficult balancing. Thank you.
Ladies and gentlemen, we would like to take a moment to thank Professor Bowman and Mr. Kallem for joining us today. We would also like to thank our many contributors. Please hold your applause until the end. Join me in extending a special thanks to the Office of the President and the Provost, the Office of Government and Community Relations, the School of Law, the Department of Political Science, the Center for Policy Studies, the Case Western Reserve University chapter of the Federalist Society, the panelists, the 2015 Constitution Day Committee, and our advisors, Dr. DeSwart, Dr. Dahl, Professor Enton, Professor Lucker, Professor Tartikoff, and Professor White. At this time, you are all invited to proceed upstairs to the Blackacre Lounge, where refreshments will be served. Professor Bowman and Mr. Kallem will join us upstairs for any questions that remain. Thank you.